So before we begin, I'd like to remind our spectators that their microphones should remain off at all times. For judges and participants, please keep your cameras on and microphones should be on mute when not speaking. So all present, so session W3 of the Walker Moot Supreme Court is now in session. It is with great honor and privilege that I present Justice Juliet Napton of the English Common Law faculty presiding, Justice Beth Quigley of Connolly Obagi presiding, Justice Chris Edwards of Templeman presiding, and Justice Tracy Lyle of Nelligan Law presiding. Justices of the panel, I present to you, speaking on behalf of the appellant, Ms. Armstrong, in today's matter before the court, Jessica Kool and Dessa Booth, and speaking on behalf of the respondent, Dr. Ward, Wafa Khan, and Nikolai Bola. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and respondent's counsel will have 30 minutes each in total, 15 minutes per council member, to present their arguments to this court, including answering questions from the bench. The appellants will present their arguments first, followed by both respondents, and then a 3-minute rebuttal will follow by the appellant. I will also signal to the court when there's 5 minutes left per speaker. Appellants, will you be using your 3-minute rebuttal?
Yes, we will.
Okay. Excellent, thank you. So the court now invites counsel for the appellant to begin.
Thank you, Ms. Tater. Good morning, justices. My name is Jessica Kool. My co-counsel, Dessa Booth, and I are representing the appellant, Ms. Karen Armstrong, in this matter. This case is about more than Ms. Armstrong seeking damages. It's also about ensuring that surgeons are held to an acceptable standard while practicing medicine. We submit that Dr. Colin Ward, the defendant, was negligent when performing a colectomy on Ms. Armstrong by coming within 2 millimeters of the ureter. Additionally, we submit that the Court of Appeal was incorrect to overturn the trial judge's decision. This is for 4 reasons. Firstly, the standard of care during a colectomy includes staying 2 millimeters away from the ureter. Secondly, the majority erred in applying the correct standard of review. Thirdly, causation can be used to inform the standard of care in this case. And lastly, the plaintiff has no duty to rule out non-negligent causes. I will be addressing 2 of these reasons, and my co-counsel, Ms. Booth, will be addressing the other 2. Dr. Ward completed a colectomy on Ms. Armstrong in February of 2010 using a ligature, which is a thermal device used to sever and fuse tissue. The ligature has potential to damage other tissue through thermal spread. Therefore, the device must stay at least 2 millimeters away from all other organs. During the surgery, Ms. Armstrong discovered that she had a blocked ureter, which ultimately led to her having her kidney removed in October of 2010. At trial, the judge held that the standard of care required of a reasonable and prudent surgeon performing a colectomy included to, quote, identify, protect, and avoid direct contact with or close proximity to the ureter when using an energy-emitting device like a ligature, end quote, and that Dr. Ward had breached this standard of care. The majority at the Ontario Court of Appeal overturned the trial judge's findings by holding that Dr. Ward did not breach the standard of care. They held that Dr. Ward took all the necessary steps to stay away from the ureter and stated that the trial judge had not ruled out all non-negligent causes. We submit that the majority at the Court of Appeal erred and that the trial judgment should be reinstated. To begin, I will first discuss what the requisite standard of care for medical negligence in Canada should be as applied to the facts of this case. We argue that the standard of care for medical negligence during a colectomy is breached if the surgeon comes within 2 millimeters of the ureter with the ligature device. Justices, we want to make it known that the standard of care required of a reasonable and prudent surgeon performing a colectomy is not contested. All of the expert witnesses, and this includes Dr. Ward, agree that the standard is to 1, identify the ureter, 2, protect the ureter, and 3, stay away from the ureter. The contested part of the standard of care is whether staying away from the ureter means being at least 2 millimeters away from the ureter with the ligature device, and we believe that it does. The trial judge found that staying at least 2 millimeters away from the ureter is a part of the standard of care during a colectomy. He held that to protect the ureter, the surgeon must stay away from it. This was a finding of fact, and it should be respected. It's a well-known and well-respected principle that courts of appeal.
I'll interrupt you there. Would that be okay?
Yes, absolutely.
So, Ms. Kool, really though, I don't think anyone, as you say, is arguing that the 2 millimeter is a very simple standard to follow. But your opposing counsel are arguing about the idea that it's not negligent. And so can you talk about how we're going to deal with that? It's not a matter of a black and white number. It's more a matter of whether that individual, that doctor, performed in a negligent manner.
Yeah, absolutely. So I think what we were just getting at is just more so talking about how it was an error of law, or just the trial judge found that the defendant, Mr. Ward, was not negligent, and that this was a finding of fact. And so we are submitting that this should be respected at the appeal level. Does that answer your question?
Somewhat, but are you still relying that they're going to be negligent if it's less than 2 millimeters? Like that is the standard that you're going to apply, is that right?
Absolutely, yeah. So we're saying that if you do come within 2 millimeters of the ureter, that is a breach of the standard of care. So we agree with the trial judge and their findings. We also submit that they're in the best position to make these findings a fact, and that should be respected. Therefore, we ultimately believe that it was an error of law for the Court of Appeal to go against these trial judges' findings of fact when there was no overriding or palpable error that the trial judge made. The trial judge also heard both parties' testimonies and the expert witness testimonies, and the judge had evidence supporting each side's view. And based on all the evidence, he made the finding of fact that coming within 2 millimeters of the ureter was an element of the standard of care, and that you have to protect the ureter by staying away from the ureter. The trial judge could have easily found that this was not an element of the standard of care based on the evidence he was given. But the fact that he did decide as a finding of fact that coming within 2 millimeters of the ureter was an element of the standard of care, we must, as a matter of law, give deference to this fact. Further, the trial judge made a finding of fact when he held that Dr. Ward came within 2 millimeters of Ms. Armstrong's ureter. Again, the trial judge could have easily found the other way. However, the trial judge is in the best position to make these findings of fact and review all of the evidence. And he did find that Dr. Ward came within 2 millimeters of Ms. Armstrong's ureter. So
Counsel,
ultimately—
Can I ask a question?
Of course.
You're saying that there's a finding of fact with respect to whether or not the doctor came within 2 millimeters.
Correct.
But you also say that he made a finding of fact with respect to the standard of care. Do you not see that there might be issues of law that may be mixed into that finding?
Yeah, so we, just reviewing all the evidence, we don't think that there was an error. We really think that the trial judge did review all of the evidence that he had in front of him, and he did not make any overriding or palpable error. And that's based on the evidence that we've seen. And so we don't believe it should be overturned.
But do you see any issue of law with respect to determining standard of care? Or are you saying it's just a question of fact?
So we think it is a question of fact. And we also say too, like, we want to consider specifically the facts of this case. So Ms. Armstrong, she was a perfect canvas, and this was quoted by expert witnesses on both sides. She had no abnormalities, no scarring, nothing of that sort. So we really believe in this situation with these specific facts that Dr. Ward should not have come within 2 millimeters of the ureter, and that it is a standard of care that would be a breach if he did. So ultimately, it follows that if it is a fact that a breach of the standard of care during a colectomy includes coming within 2 millimeters of the ureter, and Dr. Ward came within 2 millimeters of Ms. Armstrong's ureter, then Dr. Ward breached the standard of care, and he's liable for Ms. Armstrong's ureter or injury. Along the same lines, defense counsel may argue that Dr. Bernstein is not a credible witness and that the trial judge should not have given as much weight to his testimony. And we would also refute this claim. Although Dr. Bernstein does not perform laparoscopic colectomies, Dr. Bernstein has special knowledge of the ligature device, and he's very familiar with colectomies. He's knowledgeable about the types of injuries that could occur from misuse of the ligature, and thus he's a very important expert witness.
Counsel, could I just interrupt for just one moment?
Of course,
just a small point, but I don't know that you addressed it in the factum. I think you might have, but maybe you could address it now. In terms of this surgeon, is this a specialty procedure, or is this a procedure that any surgeon with general surgical skills should be performing? Is he holding himself out as an expert?
Yeah, no, so he is not an expert, but this was also described by witnesses as surgery 101. So my understanding of that is that anybody can perform this. It's surgery 101, it's basic, and Ms. Armstrong had no abnormalities to make this surgery more difficult than it should have been. It was everything, all the evidence here really plays to the fact that it was a simple procedure that Dr. Ward should not have issues with, but for negligence in this case. So going back to Dr. Bernstein, Dr. Ward, he had no issues with Mr. Bernstein as an expert witness during trial. And he actually even declared his respect for him during his testimony. Furthermore, it was completely up to the trial judge to decide how much weight to put on Dr. Bernstein's evidence. As we've already discussed, the trial judge is in the best position to make findings of fact. We must defer to the trial judge in this case. Dr. Ward and his counsel may also suggest that we are imposing a standard of care by stating that coming within—
I just want to be clear. You're not suggesting that this court is somehow bound by the trial court level decision.
We don't think that they're bound by the trial judge decision. We just think that as a matter of law, we must respect their findings of fact. So in terms of the standard of perfection, we do not think that this is the case. We do not think that it's a standard of perfection that we are imposing. Although it's true that Dr. Ward is only required to perform reasonably as a surgeon, it's not unreasonable for Ms. Armstrong to expect to have her ureter not injured during the colectomy. In this surgery, the ureter is nowhere near the colon, and in this surgery, Ms. Armstrong's anatomy was declared by expert witnesses on both sides to be the perfect canvas. She had no inflammation, no disease, no tumor, no scarring. There were no abnormalities that required Dr. Ward to widen his area of surgery and come close to the ureter that is centimeters away from the colon. Surgeons should be nowhere near the ureter during a colectomy, and this was expressed by expert witnesses on both sides. And this is especially true for an anatomically normal canvas, such as Ms. Armstrong. It is not a standard of perfection to expect Dr. Ward not to be near the ureter because there was simply no reason for him to be there in the first place. This is not a standard of perfection, it is a reasonable expectation. Defense counsel is likely to further argue that we are unfairly classifying coming within 2 millimeters of the ureter as a goal rather than a step. This argument about goals versus steps is merely semantics. Almost any part of the surgery can be classified as a step or a goal. In a colectomy, the goal of the surgery is to remove the colon. However, removing the colon is also a step that the surgeon must take during the surgery. Furthermore, staying away from the ureter with the ligature device is a goal of the surgery, but it is also a step that the surgeon must take in accordance with the standard of care. Whether these things are classified as a step or a goal does not negate the fact that these are essential parts of the surgery. Dr. Ward simply should not have been near Ms. Armstrong's ureter given its multi-centimeter distance from the colon and Ms. Armstrong's anatomy. On the next issue, which is whether the majority erred in applying a correctness standard of review, we submit that the majority did err in applying the correct standard of review for similar reasons discussed before. As previously discussed, the trial judge is in the best position to make these findings of fact. He made a finding of fact when he held that the standard of care for a surgeon performing a colectomy includes refraining from coming within 2 millimeters of the ureter with the ligature. Additionally, it is a finding of fact that Dr. Ward did in fact come within 2 millimeters of Ms. Armstrong's ureter. With respect, the Court of Appeals does not have authority to alter the trial judge's findings, of fact when the trial judge made no overriding or palpable error. We submit that the correct standard of review is to defer to the trial judge on findings of fact. The Court of Appeals' primary purpose is to review errors of law and should not alter trial judge's findings of fact. Thank you for your time, Justices. I will now turn it over to my co-counsel, Ms. Booth.
Good morning, Justices. My name is Dessa Booth. The first issue I will address is whether causation can be used to inform the standard of care in some cases. It is our position that causation ought to be used to inform the standard of care in this case. Fontaine is a case that replaced res ipsa loquitur with the doctrine that circumstantial evidence should be considered with direct evidence in cases with little to no direct evidence to determine whether negligence has been established on a balance of probabilities. Contrary to what the respondents might submit, causation can be used to inform the standard of care in certain circumstances and necessarily should be used here. The circumstances in this case demonstrate that this is a key situation in which circumstantial evidence needs to be used to inform the standard of care. Miss Armstrong's damage would not have occurred without negligence. No party nor expert contests that coming within 2 millimeters of the ureter may cause damage. In fact, every expert witness and Dr. Ward agrees that a crucial part of the surgery is identifying and taking steps to stay away from the ureter, as damage could occur if not. Additionally, Ms. Armstrong was a patient with no medical issues. Yes.
Counsel, can I ask a question?
Mm-hmm.
You're talking about causation informing the standard of care. If that's the case, if that's your position, does the trial judge then not only have to look at what happened, but does the trial judge have to consider non-negligent causes of the injury?
Yes, the trial judge absolutely has to consider non-negligent causes, and we do not contest that. This is something that I actually will get to on my fourth issue about whether the the plaintiff has a burden to rule out non-negligent causes, but the trial judge absolutely should consider plausible and significant non-negligent causes.
And did the trial judge do that here?
We actually believe that the trial judge did do that. One of the things that we actually submit is that we really think that non-negligent causes should not be at issue here at all, because the trial judge did consider these and subsequently ruled them out. And as my co-counsel, Ms. Kool, had spoke about, this is, I think, really a finding of fact, and it should be respected by higher courts.
I'll let you proceed. Go ahead.
Thank you. So additionally, Ms. Armstrong was a patient with no medical issues, which constituted an ideal setting for surgery according to expert witnesses on both sides. The incidence rate of ureter injury during a colectomy is less than 1%, and that's when taking into account medical anomalies that make surgery more difficult. Therefore, the incidence rate of ureter injury in an ideal patient would be much less for Ms. Armstrong. Furthermore, the ureter is centimeters away from the colon as expressed by Drs. Hagen and Bernstein. Therefore, there is no reason why the ureter should have been damaged other than for negligence. And finally, there's no evidence as to why—
Sorry, so can I ask one question about your statistic, the 1%? Out of that 1% that do not have good outcomes, would it be expected that ureter damage would be part of that 1%?
I believe actually that statistic was specifically for ureter damage. But yeah, it is for ureter damage. Is that what you're asking, Justice?
Well, yes, I'm just trying to get a handle of, you're saying that the incidence would be less than 1%. So 1% of the time, is this statistic supposed to tell us that 1% of the time, even a doctor who is not acting negligently could cause this type of damage?
Yes, so 1%, it would be 1% of the time. However, we do want to stress that this percentage, really, it does include a lot of times when people are receiving colectomies, they have inflamed colons or potential other issues, which is like which is the reason why they're actually getting this colectomy. So it ultimately makes the surgery more complex and would increase the likelihood that ureter damage would occur. However, in this case, Ms. Armstrong, as expressed by both sides, was really an ideal patient, and she had no complications. So there really is no reason why ureter damage should have occurred here. So finally, there is no evidence as to why this injury occurred. Dr. Ward's testimony could be used as evidence to inform the facts of this case. However, as he's on trial, this may be problematic.
I'm going to stop you there as well. I'm sorry. I would really like you to just help me to understand that a little bit more. So why is this not an accident that is acceptable? Simply because, again, you're relying on the 2 millimeter standard? Like, is that it?
Sorry, Justice, could you rephrase that if you don't mind?
Well, I'm just sort of wondering about this idea that, you know, as doctors, right, there is room for a doctor to make a mistake.
Mm-hmm.
And what is it about this that isn't like an honest mistake? Like, why does it take it out of the Wilson category?
Personally, just because really based on the expert testimony, they really, on both sides, the experts had expressed that the incidence of even accidents here is so low. And again, Ms. Armstrong is really an ideal patient here. And the trial judge, in our submission, we think adequately considered kind of the incidence rate of maybe an accident. The only thing that's being contested here really is whether every expert witness agrees that you need to take steps to protect and stay away from the ureter. The only difference in the opinions from both sides is that coming within 2 millimeters, so not staying away from the ureter, does not constitute negligence. However, if we believe that if they have to protect and stay away from the ureter, if they come within 2 millimeters of the ureter, this is negligence. There should be no reason why they're coming close to the ureter. So to sum up, Fontaine establishes that causation is used to inform the standard of care in certain circumstances. This case of medical negligence is a circumstance in which it should be used, as the circumstantial evidence is crucial here. Therefore, we submit that the trial judge did not err by conflating the standard of care and causation. The next issue I will address is whether the plaintiff has a duty to rule out non-negligent causes. We submit that the plaintiff does not. A positive duty to rule out non-negligent causes creates an unfair dynamic in medical malpractice cases. Additionally, Fontaine established that there is no burden on the plaintiff to rule out non-negligent causes. The burden is on the defendant to present these to the judge if they wish. The medical professional defendant is in a much better position to analyze and present non-negligent causes due to their increased medical knowledge and support system. In medical malpractice cases, the patient often has little to no medical knowledge. This is the reason why they go to the doctor in the first place. Medical professionals, on the other hand, are rigorously trained for their profession. Additionally, a patient often has fewer resources than a doctor in medical malpractice cases.
Counsel, I think I'm with you on all of the things you've just said there, but I'm sorry, I'm a bit stuck on your statement about how the plaintiff does not have a burden to address non-negligent theories or whatnot, and I agree. I don't believe that necessarily has to be a burden, but the point is that these have been raised by your opposing counsel, and so could you talk for a few minutes about why Dr. Klotz's theories of the matter are not as compelling?
Yeah, so actually one thing that we submit is that we really do not think that the non-negligent causes should be at issue here. The trial judge is in the best position to make findings of fact, and the trial judge had considered non-negligent causes and subsequently ruled them out. and did find that on a balance of probabilities, Dr. Ward was negligent. And so this was also alluded to in Justice Van Rensburg's dissenting judgment at the Court of Appeal. Therefore, we respectfully think that the majority of the Court of Appeal erred in their statement about that the trial judge did not adequately rule these out, because we believe that they did.
Counsel, so is it sufficient then for the trial judge to make a finding that it's likely that the injury was caused by the negligence that was identified by the plaintiff? Is this sort of a red herring?
I do not believe that is true. I mean, the burden for negligence here is on a balance of probabilities, which is 51%. So the trial judge just has to be 51% sure that, or on a balance of probabilities, that negligence occurred. These, I believe that substantial and significant non-negligent causes were raised, and the trial judge did adequately consider these, while also considering the expert testimony from both sides. And by considering both on a balance of probabilities, felt that due to the expert testimony, the incidence rate of this, and the fact that Ms. Armstrong was an ideal patient, that really negligence was what caused the ureter injury in this case. All right, just to get back to the plaintiff and their duty to rule out non-negligent causes, we also want to stress that Fontaine has established that the plaintiff bears no duty to rule out non-negligent causes. The plaintiff still bears the duty to establish negligence on a balance of probabilities. However, no duty is imposed on the plaintiff to rule out these other non-negligent negligent causes. Once negligence is established on a balance of probabilities, the defendant may offer alternative non-negligent causes to rebut this inference of negligence. If the defendant is successful in providing a reasonable non-negligent explanation for the injury, then the inference of negligence is neutralized and the plaintiff claim fails. However, as I already spoke about, these were brought up at trial and the trial judge did subsequently rule them out. Justices, in the last couple minutes, I will briefly sum up the issues that we have addressed today. Firstly, we respectfully submit that the Court of Appeal erred in applying a correct standard of review. The trial judge is in the best position to make findings of fact, and respectfully, we submit that their findings should not have been altered. Secondly, the standard of care is breached if a surgeon comes within 2 millimeters of the ureter and therefore was breached in this case. This is not a standard of perfection. It is expected that a surgeon takes great care to stay away from the ureter to prevent damage, and coming within 2 millimeters of the ureter breaches the standard of care. Thirdly, causation can be used to inform the standard of care in this case. Finally, the plaintiff has no duty to rule out non-negligent causes. Fontaine establishes that the defendant has an opportunity to negate negligence with non-negligent causes, however, places no burden on the plaintiff to rule these causes out. It follows that we submit that Dr. Ward was negligent when performing the colectomy on Ms. Armstrong. He came within 2 millimeters of the ureter, which is a breach of the standard of care required of a reasonable and prudent surgeon. We seek to set aside the judgment at the Court of Appeal and restore the trial judgment. Thank you for your time today.
The court now invites counsel for the respondent to begin.
Good afternoon, justices, colleagues, friends, and family. My name is Bola, and along with my co-counsel, Wafa Khan, we are here today on behalf of the respondent, Dr. Colin Ward. My colleague and I will be addressing 3 main points to the court today. I will address the issue of causation, and which in my submission simultaneously covers non-negligent causes. Following that, my colleague will address the standard of care and the standard of review. My submissions consist of 2 key points. First being that the trial judge improperly concluded that an injury to the ureter was a result of negligence by utilizing causation as circumstantial evidence. And secondly, that the trial judge did not consider a second and likely cause of the resulting injury. My first point, that the trial judge improperly concluded that an injury to the ureter was a result of negligence by utilizing causation. The definition of the standard of care relied on by the trial judge was an error of law, and causation should not have been used to define the standard of care in this case. The generally accepted law in Canada is for the court to first determine what the requisite standard of care is, and then determine causation. As reiterated by the Court of Appeal, in some instances where the finding of causation is essential to determining the standard of care, then on a case-by-case basis, it may not be an error of law to do so. The appellants rely on these instances in which the courts accept causation in fact prior to determining the breach. For example, in the 2005 Ontario Court of Appeal case, Brass v. Women's Hospital, the judge concluded that determining the standard of care, that the judge concluded determining causation was essential to informing the standard of care because there was no other explanation to causation other than the negligent act. This differs from our case because there was other possible unexplored non-negligent acts. In this case, the court would need to rely on the trial judge's inference of causation to consider this reasoning to be correct in law.
Also, can I just interrupt you just for one moment, because you made mention to it and it's in your factum as well. I just want to get some clarity on that. You note in your factum, I think paragraph 7, that the unexplored scenario could have been seen as a non-negligent cause. Now, isn't it the duty of the defendant to put their best foot forward in terms of that evidence to present another possible scenario? And was that done in this case?
So in this case, actually, this other possible non-negligent cause was raised by the plaintiff's expert. So we submit that because it was raised by the plaintiff's expert, that the trial judge actually had a duty to explore that second possible scenario, in which case he did not in this case.
And so just to be clear then, that the defendant did not lead evidence about another potential cause. Is that correct?
Well, there was the two other potential non-negligent causes, one of dexterity and one of the periodic vermiculation, where a prudent surgeon could not, that it may have been an unintentional injury in that case. So that was raised by the defendant, but this particular instance that I'll discuss was actually raised by the plaintiff.
But wasn't it raised and rejected by the plaintiff's expert?
It was not, actually. So Dr. Klotz raised two scenarios, one in which it was damage directly to the ureter, and he also said that the other possible scenario was injury to the blood supply, which I will actually address in great detail in my second point. The court would need to rely on the trial judge's inference here that there must be no other explanation that Dr. Ward coming within 1 to 2 millimeters of the ureter with the ligature causing thermal damage directly to the ureter. We believe this is flawed reasoning because it was clearly stated in the Court of Appeal at para 52 that the trial judge did not make any findings of fact that the only possible way the ligature could have come within 1 to 2 millimeters of the ureter is by a negligent act. Accepting the appellant's reasoning of the trial judge correctly utilizing causation to inform the breach is by accepting that the trial judge's finding of causation is in fact based on negligence. Additionally, if the trial judge is prepared to move forward with the mindset that the only possible cause of injury is by a negligent act, then that judge has the obligation to consider and rule out all non-negligent causes. Here, the trial judge concluded there was a negligent act, but failed to rule out the cause, the other non-negligent cause.
Counsel, can you just remind me, when you're making that statement, is there a case I should be looking at to support that statement?
So the Court of Appeal did not reference a secondary case here. So we were just going off of the higher court's authority while making this ruling. We respectfully put to the court here that the trial judge did not fulfill his obligation to consider, explore, expand, and rule out all non-negligent causes specifically what I briefly touched on, the scenario advanced by the plaintiff's expert, Dr. Klotz, at the initial trial. He offers the second suggestion that another cause could have been thermal damage to the surrounding blood supply.
Counsel, didn't he do that by inference, though, by making a finding of fact that it was by getting close in proximity to the ureter that constituted negligence? Didn't he, by inference, conclude that a non-negligent event was not at play here?
So based on the finding of the standard of care definition relied on by the trial judge was that the negligent act would have been coming between 1 to 2 millimeters of the ureter. So our position is that it's possible that Dr. Ward came within 1 to 2 millimeters of the blood supply, which could have put him more than 1 to 2 millimeters away from the ureter itself.
And what was the expert's view as to whether that would constitute negligence if that were in fact the case?
So that's actually part of my submission, is the fact that we would need the expert evidence to explore that further, and that wasn't done here. And so because it was put forward by that expert, the trial judge did have the obligation to explore that further so that we could have answers to these questions.
Thank you.
Thank you. So moving on to my second point, that the trial judge erred by not considering the second likely cause. Within the definition relied on here by the trial judge, Dr. Ward could have been exonerated from liability if it was found the injury was to the blood supply, because it was possible, as I just said, that he could have been more than 1 to 2 millimeters away from the ureter. I would like to draw the court's attention to the trial judgment at para 97, and here I will quote Dr. Klotz. He states that the likelihood
Counsel,
is that—
am I supposed to be following you there? Am I supposed to be moving to that page?
I was just going to draw the attention, but if you'd like to move to that page, absolutely, because I will be quoting directly from the judgment, or from the statement.
Could you direct me to it?
Pardon me?
Could you direct me to it?
Yeah, so it's para 97 of the trial judgment, the 2018 Ontario. Okay, thank you. So he stated here that the likelihood is that it was a thermal injury either to the blood supply or to the ureter itself. Here, Dr. Klotz proposed two distinct scenarios. He singled out the ureter by adding the word itself after, implying that his second suggestion of damage to the blood supply was a separate and likely cause of the damage to the ureter. Dr. Klotz continued to explain to the court the reasons why he personally believed that the thermal damage to the ureter was the correct version of events, which was then accepted by the trial judge. However, he failed to explain to the court why the second scenario he had just mentioned was seconds later not likely at all. If the blood supply—
Counsel, can I just ask, I mean, if the expert is giving their opinion and they're saying there's two possible occurrences that could have taken place, and then accepts that one of them is the likely injury that occurred, why would it not be subject to cross-examination or the obligation of the defendants to either call evidence to contradict that expert or on cross-examination raise issues with respect to his opinion? Why can we not just accept what his opinion is if it hasn't been seriously challenged at trial?
So we submit that it should have been raised at trial, but the ultimate obligation would be on the trial judge to rule out that cause.
And why is it the trial judge that has that that responsibility? It's not their responsibility to make out the defendant's case, is it?
No, it is not. But based on when the trial judge is prepared to move forward that only a negligent act could cause the injury, then it is their responsibility to rule out the other non-negligent causes brought forward. So this is reiterated at para 56 of the Court of Appeal for your reference. Sorry, yeah, does that answer your question?
Why don't you tell me what paragraph 56 says?
Sure. So paragraph 56 says, a trial judge who is prepared to proceed on the basis that only negligence could cause the relevant injury is obliged to consider and rule out non-negligent causes. Only if this is done, can the trial judge properly use success as the standard of care.
And you argue that in this case, the trial judge used success as the standard of care.
Correct. And my colleague will follow up on that in her submission. Thank you.
Can I ask you one question about the standard of care? You're saying that the standard of care issue is an error of law, and your friends have already made the submission that the standard of care is an error of fact. So your factums and your arguments seem to be two ships sailing against in different patterns. So can you please explain to me, is the standard of care, the findings made by the trial judge, are they questions of fact or are they questions of law?
So my submission is more on the finding of fact. My colleague will address more the areas of fact and law. So in the standard of care, I believe it's, pardon me one moment. I believe it's the second. Kind of losing my place here a moment, my apologies. So we are arguing that it is in fact an error of law. And my colleague will go into depth about that in her submission. So if it's okay with the court, if I could finish my submission and then she will address that in her submission. Okay, thank you. So if the blood supply scenario was considered by the court, they would have been presented with the expert evidence suggesting that there's 3 points of contact with the blood supply surrounding the ureter. And if thermal damage occurred to the blood supply, it could have eventually caused the unfortunate end results of Miss Armstrong's injury. The trial judge relied on the importance of consistent expert evidence as reiterated by the Court of Appeal. However, the amount of consistency measured by the court was only relevant to one of the two scenarios. Dr. Bernstein and Dr. Klotz's expert evidence was consistent with the theory of the damage to the ureter. And had the damage to the blood supply scenario been considered, then the expert testimonies of Dr. Robinette and Dr. Hagen would have been consistent in supporting that theory. Dr. Robinette had testified that the scarring, adhesions, and fibrosis observed by Dr. Hartsberg could happen even if the ligature was used more than 1 to 2 millimeters away. His opinion was that the damage was not caused directly to the ureter because if it had been, Ms. Armstrong's symptoms would have developed within days. In this case, it took 21 days.
My apologies, counsel. Your 15 minutes is up.
Okay.
I will now defer to your co-counsel.
Thank you.
Good afternoon, Justices. My name is Wafa, and I will be making 2 submissions today on behalf of the respondent, Dr. Ward. My 2 submissions will be as follows. Number 1, the standard of care in medical negligence in Canada as it applies to this case is one of reasonableness. And number 2, the Court of Appeal did not err in applying a correctness standard of review. To begin, we submit that the requisite standard of care in medical negligence in Canada as it applies to this case is one of reasonableness. What the trial judge proposed as the definition of the standard of care was based on perfection, not reasonableness. And we would be doing a disservice to 65 years of medical negligence history if we alter the standard of care of reasonableness, which was established in the well-known case of Kritz and Sylvester in 1956. What the trial judge suggested by his finding was using the end outcome of a surgery, which is a goal a physician has in performing their procedure, to define that standard of care. This suggested standard imposed a strict duty of perfection on surgeons, expecting a perfect outcome every time, and that is simply not reasonable. A physician's obligation is to exercise a reasonable degree of care and skill in the steps that they take to perform a procedure, and they should not be judged by the outcome of that procedure. An injury to the ureter does not mean that Dr. Ward did not follow the steps of the procedure as reasonably as possible. And this takes into consideration other alternative factors or causes to the injury. But if we are to accept the trial judge's definition, we are incorrectly concluding that because the ureter was injured, it automatically implies Dr. Ward was negligent, even if he did follow the steps.
Counsel, I'm just unclear with that argument in the sense that, and correct me if I'm wrong, but my understanding from what's been presented to us earlier here today is that all of the experts agreed that in fact, Dr. Ward got too close to the ureter, that he did not stay 1 to 2 millimeters away as was required. If that's the case, if the trial judge concludes that based on the overwhelming evidence given by all the experts, then how do you argue that his conclusion was based on the outcome rather than just the finding that he got too close to the ureter?
I think this would touch into the circular reasoning aspect. So if you're using the end goal to define the standard of care, at the end of the day, if you breach that standard, that means you didn't achieve your end goal. And if you don't achieve your end goal, that means you breached the standard. So they kind of go back and forth. And that's where the idea of perfection comes from, is that even if you do follow the steps, and even if the outcome isn't perfect, that means that you breached the standard. Does that answer your question?
Well, continue on and I'll see if I follow. Thanks.
Okay, thank you. Asserting a standard of perfection by suggesting that avoiding the injury constitutes a standard of care creates absolute or strict liability on medical professionals. And this fails to take into consideration accidents or other non-negligent causes that could injure the ureter during a procedure. And this brings me to another key point about the standard of care and why it should be one of reasonableness and not perfection. To accept this heightened standard of care sets a dangerous precedent for the future of our healthcare system by imposing absolute or strict liability on healthcare professionals. In Kurtz and Sylvester, it was stated, and I quote, "But we should be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Doctors would be led to think more of their own safety than of the good of their patients. Initiative would be stifled and confidence shaken." If the court here today accepts the standard of care as defined and applied by the trial judge, we would ultimately be responsible for the collapse of our healthcare system. We would be responsible for imposing absolute or strict liability on healthcare professionals undertaking this surgery or possibly any similar surgery. And by suggesting that this is a case where causation can be determined before the standard of care to define it is dangerous in the world of medical malpractice, because future courts will turn to this case we are arguing before you today to justify applying this incorrect standard of care. And this
Counsel, can I just interrupt you just for a moment? Should we expect more from a surgeon who's doing this type of complex surgery? Should we be imposing, for example, a strict liability in circumstances where somebody has the level of knowledge required to perform surgery of this exacting nature? Or is it your position that this is not a specialized type of surgery?
So this is not a specialized type of surgery because it was even decided in the trial judgment that he is a general surgeon. They didn't classify him as a specialist. So if he was to be a specialist that only had this requisite knowledge or only performed these types of surgeries, if he was specifically the surgeon, then the standard of care would be heightened. But at the end of the day, imposing absolute or strict liability, again, as I will touch upon right now, is going to be very damaging on the healthcare system. Does that answer your question?
I'm sorry, I have a follow-up question. So here you're talking about standard of perfection.
Mm-hmm.
And the doctor initially testified, I assume, that he stayed away from the ureter by, 5 to 15 centimeters away. And the trial judge made a finding that he came within 2 millimeters. That seems like in the human body, that seems like a pretty far distance away from where he should have been. Would you not accept that if the trial judge made the finding that he came within the 2 millimeters, he's just basically rejecting the evidence of the defendant in terms of what he was actually doing, and accepted that he lost sight of where he was supposed to be?
I do agree that the distance between 2 millimeters and 5 to 15 centimeters is quite large. However, this would be something that could be one of those accidental acts that I will touch upon in terms of two different possibilities. One is when the ureter is off screen, and the other is the magnification of the screen. So those are two separate and distinct possibilities that could have, in Dr. Ward's mind, altered the actual distance that he was believing that he was maintaining. Did that answer your question?
Well, I'm interested to hear how you can get within 2 millimeters when he believes he's at least 5 to 15 centimeters away. So I'm looking forward to hearing how you can explain that.
Right. Thank you. So this would alter the fundamentals of the physician-patient relationship. Our healthcare system is already overflowing with patients in need of life-saving surgeries, but with no physician available to take on this surgery because of the liability that's associated with it. And even for physicians that are willing to perform this type of surgery, we can expect poor access to timely healthcare. Residents of Canada are already experiencing extensive wait times to see specialists and undergo necessary procedures, but to impose even longer wait times due to a limited number of doctors who are capable of doing the surgery but are picking not to, is going to destroy the trust that society has in our legal system, because we would be the ones responsible for creating this liability. And not to mention that these physicians are going to be under emotional, physical, and mental stress while performing these types of intricate surgeries, which could actually lead to more accidents. But by the definition of the trial judge's standard, this would automatically imply negligence. So as you can see, there really is no way for physicians to uphold their sacred oath and perform their duties without fear of severe repercussions if anything was to prevent the surgery from being successful. And this includes accidents or other non-negligent causes like a patient's pre-existing history.
Okay, but is there any evidence here that there was a pre-existing history, Counsel? Is there anything that would help us to understand why what would appear to be such a very simple or whatever easy standard to meet hasn't been met?
So it was submitted by my opposing counsel that the colon was benign. However, what was failed to be considered was that in the Court of Appeal, they do discuss how any prior procedures could affect the outcome. What was not discussed here was that Ms. Armstrong had had a partial ileostomy about a year prior, and partial ileostomies about a year after they're performed are also known to cause injuries to the kidney and lead to kidney failure. But this was something that was not explored. So this is just another possible pre-existing medical condition that could have affected it, but was just not discussed. Did that answer your question?
Well, why wasn't it discussed?
That's an excellent question. I believe it wasn't discussed at the time because none of the experts had raised it. And at that point, Ms. Armstrong's ileostomy had been only done about a year ago. So if there was anything that could have affected it, it was not known at that time.
So, Counsel, are you suggesting that we should, with our limited medical background, make medical findings about the pre-existing condition of this patient when that evidence was not put forth at trial?
No, absolutely not. This was just a mere example of something that could have affected it. And it was just an example of why non-negligent causes and pre-existing history should be taken into account. But in this case specifically, it was non-negligent causes and accidents that were not taken into account, not the pre-existing history of her intestine. So what the trial judge also fails to consider is accidental acts or omissions that could have resulted in the ureter injury, which was just briefly elaborated on by my co-counsel. And one of these accidental acts would be an error in judgment. So if the court refuses to believe the alternative causation theory elaborated on by my colleague and accept that Dr. Ward did in fact come within 1 to 2 millimeters of the ureter, then he cannot be held liable for what would be an error in judgment. As I have alluded to in our written submissions, there are 2 possible scenarios that this could have happened in. Number 1, Dr. Ward, while he believed that he was honestly 5 to 15 centimeters away from the ureter at all times, may have unknowingly misjudged this actual distance between the ligature and the ureter while this area was off screen. And number 2, Dr. Ward was utilizing a screen that magnified the anatomical features he was performing the procedure on. While it was not submitted at trial what this magnification level was, it's very possible that the image on the screen was not reflective and not to scale of what Dr. Ward honestly believed in his mind he was maintaining.
Counsel, I have no problem with a doctor, having, not being a perfect human being, but I'm having a hard time jumping between that and various theories and scenarios that theoretically could, I agree, could have affected things, but weren't before the trial judge, were not put into play. I don't know how that helps me today.
So what was mentioned at the trial at the trial court by Dr. Ward was that when he's in a magnified view, it's really hard to actually estimate the distance because there's no tool to measure the distance in the abdominal cavity. And so the distances that he is measuring is completely based on estimation. And while adjacent structures might be present, within certain magnifications, you might not see everything. And the other thing to consider is that what you're viewing on the screen is a 2D image of a 3D anatomical feature. So it's not going to take into consideration depth perception or spatial, the spatial relationships as well. So that's why this was something that was mentioned by Dr. Ward, that it's possible that the magnification could have altered things, but that even though he did believe he was maintaining the distance, this is something that could be considered an accident.
Wouldn't it be the doctor's responsibility to put forth that explanation as to what happened that would have gotten him that close? I mean, I get that, you have potential magnification issues, but in my mind, 5 to 15 centimeters is a pretty large gap to meet for a surgeon. And, if for some reason there was an explanation that was in this line, wouldn't it be the doctor who ought to have been able to put forth this as evidence as to explain what happened here?
So Dr. Ward did bring it forward, and he did say that in a magnified view, it's hard to estimate the distance, but then this was rejected.
Right, as a finding of fact.
Yes, yes.
And and you'd agree with me, we should be giving deference to the trial judge on findings of fact?
On certain ones, yes. However, as I'll explain later, when it comes to questions of the standard of care and the law, that does not need to be owed deference. On facts, yes, but on law, not.
Okay.
So the standard of care is about whether or not the physician was reasonable in taking the steps required of them. It's not about whether a physician took some steps and then decided not to take any others. What is required is for the physician to demonstrate they take every step and are as reasonable as possible in those steps. And the key word is reasonable. They don't have to be perfect and they don't have to be successful. And when a surgeon is performing a procedure, they don't have just one goal in mind. They actually have multiple goals, like making sure the anesthesia doesn't wear off before the procedure is completed, identifying and trying to protect major organ systems, and even just completing the procedure. So to hold physicians to an impossibly perfect standard with guaranteed liability is simply wrong. And binding Supreme...
My apologies, counsel, to interrupt. Unfortunately, your 15 minutes has come to a close.
Okay.
The court now invites counsel for the appellant to begin their 3-minute rebuttal.
Thank you. So we want to stress that the colectomy is not complex. It's surgery 101. The ureter is not near the colon. Perhaps if the ureter was closer to the colon, we'd have a completely different situation. But because the ureter is so far away, Dr. Ward should not have been over there but for negligence. In terms of the non-negligent causes, not only did the trial judge rule it out, but defense expert witness Dr. Klotz even stated that the injury occurred because Dr. Ward came within 2 millimeters of the ureter with the ligature. Non-negligent causes were ruled out by the trial judge, and this should be respected as a finding of fact. Any other new non-negligent possibilities were for the defendant to bring up during trial, not at the second stage of appeal. We also want to stress that it is important to look at the specific facts of this case. Ms. Armstrong is anatomically normal and had what expert witnesses on both sides referred to as a perfect canvas. The risk of injury to the ureter for this surgery is between 0.15% and 0.66%. This number takes into consideration that many patients that have had their colon removed because of disease. In the absence of this, Ms. Armstrong's injury should have been way less than 1%. So from this alone, it seems that on a balance of probabilities, this injury would simply not have occurred but for negligence. We are not expecting perfection. In the specific facts of this case, the ureter is not near the colon and Ms. Armstrong is anatomically normal. Dr. Ward had no reason to be near the ureter. Therefore, it's not unreasonable to expect Dr. Ward not to come within 2 millimeters of Ms. Armstrong's ureter. In summary, we would ask that the court keep in mind the specific facts of this case during deliberation. And again, we thank you for your time today, Justices.
Justice Napton, did you have a follow-up comment or question?
I just wanted to thank all of the participants. I think that, are we done, Ms. Tater?
We do. I can conclude the matter of Armstrong and Royal Victoria Hospital. And Justice Napton, I would invite you to offer some concluding remarks if you wish.
Well, we're not allowed to speak with each other. And as you know, we're all in different spots, but I think I probably can speak on behalf of everybody to say that it was a very impressive round. I don't know what year you are all in your legal education, but some very, very good work here, some very calm and confident advocacy. I think being able to respond to a question from a decision maker, no matter how out of field or how weird it is such an incredible skill to have. And I think all of you showed it today. Very, very impressive. So that was fantastic. So thank you very much. I don't know if any of my other judges wanted to say a couple words.
I'll just say that this was a tough bench. You got a lot of questions. And I think you did very well. And in fact, I think that I thought all of you have really good early skills as litigators. And the way that you handled those questions was quite impressive, because it can be very scary when you're taken out of your zone and you have to respond to a judge's questions that were quite technical, including requiring you to come up with paragraphs. And I mean, Justice Napton, I think it was shocking and appalling that she would go to that level of detail with you. But you did very well. I thought you were excellent, all of you.
Well, thank you, Justice Edwards. Justice Quigley?
I don't have anything to add. I concur.
Wonderful. Well, thank you. Oh, Justice Lyle, sorry.
I'll just say the same. I'm very impressed. I would have been, as we were talking before we started, much more nervous at your stage doing this sort of mood. It's quite, you all did a fantastic job, and I was really impressed by your poise before the camera and before the court. So great job.
Wonderful. Thank you so much. Well, on behalf of the Health Law Students Association, thank you everyone for your participation this afternoon. A special thank you to our esteemed justices for taking time out of their weekend to join us. Judges, if you could kindly send in your score sheets by 1:15, that would be greatly appreciated. And additional information can be found in your brief with regards to the email address to send that off to you. So everyone, please feel welcome to join either of the two semifinal rounds beginning at 2, as well as the final round beginning at 4 p.m. So thanks again, and have a great